Just another little short video on debt collectors. At the moment, a lot of people are being hit with enormous bills. They're not getting decent enough wages, and debt collectors are coming after them left, right, and centre. So hopefully, this will help you to realise what a debt collector is and what we can do about kicking them into touch. So we need to find out who a debt collector is by the Private Security Personal and Private Investigators Act 2010. I'm talking about New Zealand here, but you'll be able to find this in your own legislation. So we go to this act, and number 4, the interpretation. In this act, unless the context otherwise requires, a debt collection agency means a person or an association of persons, whether incorporated or unincorporated, who for valuable consideration recovers or attempts to recover for a person any money owing to that person by another person. Okay, so a debt collector doesn't have a contract with us, so they're going to normally contact us via a letter, and it'll be similar to this. Most of them are fairly similar, and they'll tell you the debt that's owed, the current balance, and they'll give you their client reference number, and they'll say something similar to this, most along this line anyway. We refer to your outstanding debt with Acme Acehole Limited, who have contracted us to collect the outstanding amount, and they'll normally say the copy of the statement is enclosed for your reference. And please make your check out to Ripoff Merchant Limited, who is the debt collection agency. Now, when most people see this, they panic and they call the 0800 number. It's a deliberate ploy, but that's going to be a problem because it puts you straight into contract with them. Everything in this life is about contract. It's all about offer and counter offer. So whenever they make us an offer, we have to make a counter offer. And I'm going to tell you now, never ever respond on the phone. Never do any business on the phone. Always respond via letter, because if you've got a letter, it will stand up in court. Any correspondence will stand up in court. Phone calls won't. So now they said that we had a debt. So first of all, we'll have a look at what it is. A debt is a contract, a sum of money due by certain express agreement. Okay, in a still more enlarged sense, it denotes any kind of a just demand. Now, when you look at demands, they must demand this, but we can thwart all this because these people are only third-party interceders. Some people called interlopers. Both are correct. They're just coming in hoping to make money out of ignorance, and it's our ignorance. Butterworth's New Zealand Law Dictionary says that debt, which is owed, a debt is normally a certain sum. Now, you will find that in any of their demands, they will never put a certain sum. And the reason they won't put a certain sum or a sum certain is because the moment they do, it's negotiable. And they don't want that. So all they will do is they'll put a dollar sign, which is a S with a line down the middle, and then they'll put some figures. They will never write the amount. So if you know these little tricks, you'll be able to kick them into touch without too much of a problem. And if we realise that all the debt collector is offering is a contract for goods and services, we can or may decline his offer. So we'll show you how to do this. But first of all, we'll give you a little bit of an idea on what goods and services are, because you need to know this. Now, in the Consumer Guarantees Act, goods means personal property of every kind. Okay, we don't need to go much further than that. It means personal property of every kind, whether tangible or intangible. Now, at any stage, you can stop this recording and just read through the rest of them, but I'm giving you the pertinent points here. So, goods is personal property of every kind, and services includes any rights. So, what they're doing by offering us these goods and services is offering to take away our rights. Okay, now, if you can read through the rest of that, but down the bottom there, contract relating to but not for the supply of gas or electricity other than line function services, but does not include any rights, privileges, benefits, privileges, or facilities that are or are to be provided, granted, or conferred by a supplier, paying or crediting any money to the consumer without the performance of any other task. Now, what they're doing is all they're trying to do is they're buying a so-called debt from the company that has defaulted or is trying to default us, and they're trying to come in as a third-party interceder to get some money for it. So now that we've seen how they take our rights, let's explore how we can rebut them. Now, if we look at the Fair Trading Act 1986, 21A, liability of recipient of unsolicited goods. Now, this is what they're offering us, is only one thing they're offering us is unsolicited goods and services. So 21A Part 1, if a person, the sender, that's the debt collection agency, sends or delivers unsolicited goods to another person, the recipient, that's us, the recipient is not liable to pay for the goods. Oh, telling you right there. But this is all the debt collection company is offering us, goods and services. Now, if you can get that clear in your mind, you'll find it very, very easy to get rid of these people. It tells you right there, 1A, we're not liable to pay for the goods or the services. We'll find out in a bit. But if we scroll down a bit there to B, must at any reasonable time during the period of 10 working days after the day on which the recipient receives those goods, make goods. Now, it goes a bit deeper here, so we'll show you. If the sender is in trade, the sender must, at the time of the goods deliver, whether by the sender or by any other person, inform the recipient of the recipient's rights and obligations under Section 1. Now, a debt collection agency will never, ever do that. And this is how we catch them. They will never inform us of our rights. Now, 4 doesn't really apply to us until we get down to 7 there. In this section, in Section 21C, unsolicited goods means goods that have been sent or delivered to a recipient, the recipient is us, without any request for those goods having been made, or on behalf of that recipient, but does not include reticulated gas or electricity. Now, those are the only 2 things that we do have to pay for, so the rest is already paid for. Okay, let's have a look at 21B of the same Act. Liability of recipient of unsolicited goods. Okay, now we are the recipient of a contract or offer of unsolicited services. If a person in trade provides unsolicited services to another recipient, to another person, the recipient is not liable to pay for those services. It tells you once again. Okay, so now we're going to have to well, first of all, we'll have a look at the Unsolicited Goods and Services Act 1975. For demands for payment, every person commits an offence who, not having reasonable cause to believe there is a right to payment in the course of any trade or business, makes a demand for payment. And this is what they're doing. They're making a demand, but for what he knows or ought to know are unsolicited goods sent to another person with a view to his acquiring them. Okay, so they're sending us these unsolicited goods and services and wanting us to pay for them. Now, just get it very clear, it's only an offer. Everything in their world is a contract or offer to contract, and if we accept it or go silent or start to argue, well, then we are going to suffer the consequences. So I'm going to show you how to respond to them in a proper manner that we've already seen we're not liable. So how do we respond? And this is the first thing. Forget about the 10 days mentioned. Respond within 3 days. Okay? It's absolutely crucial to respond within 3 days. Now, what they will do is they'll try all sorts of tricks to try and trick us into going the 10 days. Their best trick is to put on the letter the date, and you won't receive the letter till 20 days later. And the most important thing is when you write the letter that you mention all those things, which I'll show you very shortly. Respond by letter only and send by courier, signature required, or registered mail. Very, very important that you keep a strict record of this, because these ratbags will try and get you. And if they keep better records than you, they will win. But if you keep better records, you will win every single time. Okay, so here's the letter that we're going to send. Okay, and we're going to send it to Rip-Off Merchants Limited, who is the debt collection agency. Now, here's another trick they use. They won't put their name. They'll put for the manager or something like that. They will never put their own name. So we immediately address, Dear Unnamed Writer. So we're telling them that they're in dishonor for not putting their name in there. Now, if we've got a record of this, and you keep a record of all the mail you send, and by the way, it's a really, really good idea if you've got the time and energy to do this. Go down to your local courthouse, and after you've done this letter, and ask for a copy, a certified copy of this letter. They don't charge you a cent. You just give it to them. They'll photocopy it and they'll put a stamp on it, certified copy. So you keep the original and send the certified copy off with the court stamp on it. And I'll tell you what, they start to panic. Okay, now what we're going to say is, Dear Unnamed Writer, greeting. We received by mail on the 19th of January 2017 an unsigned flyer purporting to be a demand notice. We're unsure as to why this flyer was delivered to us, as we have not agreed to do business with Rip-Off Merchant Limited and do not recall signing any contract for Rip-Off Merchant Limited for provision of services. So we're telling them what they're offering us, that we do know our rights. If we have signed a contract with Rip-Off Merchant Limited to provide us with services, would you kindly refresh our memory by providing us a copy of the agreement? So what we're saying is, okay, you guys are trying to say that we should pay you, but we don't have a contract. And if you don't have a contract, they do not have a leg to stand on. Okay, so now we're going to notice them. Should you fail to provide us with a copy of our agreement and provide a person's name, now you must have the person's name, and they do not like that. The moment you ask for a name, they normally go away because they do not want to put their name to it, because if they sign it and put their name to it, they can be done for fraud after we have given them this notice. Provide a person's name that we can communicate with. We will consider this matter at an end and notify you that any further demands for unsolicited goods and services will be regarded as a claim for unjust enrichment in contravention of Fair Trading Act, which we explain further, and Unsolicited Goods and Services Act 1975, Section 4, which we also mentioned further. And we'll forward this to our solicitor for action. Yours sincerely, a ratbag. Okay, now that normally is enough, but sometimes they get a bit more persistent and they will send you a second letter and sometimes a third, but you must respond to everyone. Now, you must be aware that they will put fishhooks in there to try and catch you out. They'll make spelling mistakes, they'll put all sorts of things in there to catch you out, and don't fall for them. All you must do is respond within 3 days. Ask for someone to sign the letter. Never, ever ignore their demands. Every response is another offer to contract, and they can only proceed with our consent because they only deal with the dead. So if we consent to anything by ignoring them or arguing to some of the points I mentioned earlier, then they will have a contract and they can proceed. Every response will be different as they will make deliberate mistakes to get us into contract. Don't fall for them, folks. Don't fall for them. Just stick to the basic premise that they have no right to offer goods and services to us without a contract. And if you stick to that for 3 times, then there is no way that they can proceed because the courts will not uphold their claim. Hope this helps you.